Welcome to part two of chapter seven, torts. And we'll continue this section with talking about intentional acts and also about negligence. And then we'll continue with part three. So let's jump into or back into where we were with types of intentional torts. So another type is trespass to chattel or personal property. This is the unlawful taking or harming of another person's property without that owner's permission. There's also, so we did that. Then there's conversion, which is the civil tort of stealing property from another person. And then something to keep in mind is nuisance is not always considered an intentional tort, but is something a little bit more than negligence. So private nuisance is interfering with someone else's use or quiet enjoyment of their land. And then public nuisance is interfering with the public health, safety, or welfare. Another type of intentional tort, and we hear this a lot, is defamation. So this is publishing or saying untrue statements about a living person that harms his or her reputation. So slander is the oral form of it, and libel is the written form. And libel occurs if the words are published to a third party. So, of course, the defense is it's not slander or libel if it's true. So keep that in mind. Now, the First Amendment gives strong protection for news organizations. And courts have shown that public figures have to show that actual malice was intended or meant or involved before they can win a defamation lawsuit. So malice is conscious and intentional wrongdoing. Uh, there's also injurious falsehood. So this is publishing false information about another person's product. So this is known as trade disparagement, uh, fraud. This is the misrepresentation of facts. Uh, so lying, that's another way of saying misrepresentation of facts. It's lying with knowledge that they are false or with reckless disregard for the truth. And it's so known as misrepresentation. Now, something that is not intentional misrepresentation is puffery. These are just simply promotional statements expressing subjective views, and sometimes they're really, outlandish or superlative, uh, but at the same time, they are not considered tortious. And then there's tortious interference. So this is the intentional damage of another person's valid contractual relationship. Now, when we talk about some of these things like injurious falsehood and fraud, as well as libel and slander, those are issues that are coming into play with Dominion, the Dominion uh, voting machines, and certain members of the Trump team. So like Rudy Giuliani uh, and others. So something to keep in mind, and that's as we know, it's a pretty famous case, and it's going on now, and uh, it'll be interesting to see how that plays out. So some key takeaways is intentional torts are many and varied, and they each require an element of intent. And then there are a variety of defenses exist for specific intentional torts. Now we move to negligence. So negligence is the breach of the duty of all persons to act reasonably and to exercise a reasonable amount of care. So it's distinguished from intentional torts because there's a lack of legal intent. So law of negligence is the expression of democracy at the community and local level. So this is the people acting because ultimately citizen juries decide what conduct leads to liability. And here we see the banana peel being dropped. So this is if someone's walking down the street or a sidewalk, eats a banana, throws the peel down on the sidewalk. They weren't intentionally trying to harm someone, but their act of negligence did lead to this person falling. Maybe he broke his leg, something like that. Some elements of negligence. So to prove negligence, plaintiffs have to demonstrate certain elements. They have to establish that the defendant owed a duty to the plaintiff. The plaintiff has to demonstrate that the defendant breached that duty. And the plaintiff has to prove that the defendant's conduct caused the injury. And the plaintiff has to demonstrate legally recognizable injuries. So this is very interesting. It's an emerging area of tort law is whether or not businesses have a duty to warn or protect customers from random crimes committed by other customers. So that's very interesting, and that was discussed in some detail in the book. So the concept of duty is broad, broad and extends beyond those in immediate physical proximity. And the general rules surrounding when a duty exists can be modified in special circumstances. But generally, that duty is the duty that we all, owe to others in our society to be responsible and, kind of mind our P's and Q's and mind the laws. So businesses owe a duty to exercise a reasonable degree of care to protect the public from foreseeable risks that the owner knew or should have known about. And business professionals such as doctors, accountants, dentists, architects, and lawyers, in my former line of work, insurance agents, owe a special duty to act as a reasonable person in their profession. So malpractice is when negligence is committed by certain professionals. So we all know about, doctors and medical malpractice. And once the duty has been established, negligence plaintiffs have to demonstrate that the defendant breached that duty. And in wrapping up negligence, so in deciding whether there is causation, courts have to consider these two questions. Whether the causation is in fact or actual causation, also known as but-for causation, meaning had he not done this, then, or had he done this, then that was not very clearly put, but for the person's actions, the injury would not have occurred. So whether the defendant's actions also, so there's the second question, so whether the defendant's actions were the proximate cause of the plaintiff's injury. And then what does that mean? So proximate causation is an act from which an injury results as a natural and direct consequence. And in determining that, we use the foreseeability test. So that wraps up part 2, and I'll see you, or you'll hear me, in part 3.